Please be seated. The sitting is open. The court meets this morning to hear the first round of oral argument of Myanmar on the merits in the case concerning application of the Convention on the Prevention and Punishment of the Crime of Genocide, the Gambia versus Myanmar, 11 states intervening. I now give the floor to His Excellency, Mr. Koko Flying, Agent of Myanmar. You have the floor, Excellency.
Esteemed President of the International Court of Justice, distinguished Vice Presidents, honorable member of the Court. As agent of the Republic of the Union of Myanmar, it is with great solemnity that I stand before you to defend my country against the accusation of violating the Genocide Convention. Myanmar fully recognizes the fundamental importance of the Genocide Convention. Myanmar signed it in 1949 and ratified it in 1956. Myanmar's presence in this great hall of justice is a testimony of the importance of the convention for my country. Today, we stand before the court to defend the honor of our country against an accusation of the utmost gravity. A finding of genocide would place an indelible stain on my country and its people. These proceedings are of the fundamental importance for my country's reputation and future. Myanmar treats the allegations and this case with utmost seriousness. As a sovereign state, fully committed to the observance of international law, it has prepared its written pleadings with the care and attention to detail that would be expected of a response to such grave allegations being determined by the principal judicial organ of the United Nations. Myanmar has complied with all procedural rules and orders of the court, including the Provisional Measures Order. This demonstrates its commitment to the international rule of law and the rule of the court. Unfortunately, the same cannot be said of the Gambia. The Gambia's inquiries into facts are rudimentary and partisan, based on reports of the fact-finding mission from 2018 and 2019, which are neither reliable nor objective, and were a condemnation without trial of Myanmar. Gambia has additionally failed to present the evidence objectively. It has furthermore nurtured a dangerous mixing of roles in which its representatives and its sources of evidence, the so-called independent NGOs and witnesses, are on the same bench. This is in no way helpful to the integrity of the proceedings and caused serious doubt on the quality of the material put before you. And an accusation of genocide is too grave to be handled in such a haphazard and unprofessional manner. Mr. President, members of the court, Myanmar's firm position is that the Gambia has failed to meet its burden of proof. This case will be decided on the basis of proven facts, not unsubstantiated allegations. Emotional language and blurry factual pictures are not a substitute for rigorous presentation of facts. This is also a case about the proper interpretation of the law, which the Gambia distorts, largely ignoring your jurisprudence, as our consul will show. The Gambia no longer denies the terrorist attacks by the ASA, which took place in northern Rakhine states in 2016 and 2017, or the need of a government response to those attacks. Obviously, Myanmar was not obliged to remain idle and allow terrorists to have free reign of northern Rakhine states. These attacks were the reasons for the clearance operations, which is a military term referring to counterinsurgency or counterterrorism operations. It's true that as a consequence of the clashes, people were killed and the large number of people left the area and went to Bangladesh. As in other instances of armed conflict and instability throughout the world, and indeed in other regions of Myanmar itself, such events will have had a huge impact on a large part of the region's population. Myanmar is well aware of the human cost of the armed conflict, instability, and terrorism. There has been historically and unfortunately still is conflict in different regions of Myanmar. The government aspires to peace throughout the country and is striving its utmost through dialogues, discussions, negotiations with all stakeholders. However, the path to peace are complex. When considering the narrow issues within the scope of these proceedings, the court cannot make assumptions about such matter as the best way forward or about the aspirations of the Muslim populations in northern Rakhine states. The court cannot assume that those responsible for the terrorist attacks in 2016 and 2017 speak for them. Nor can the court assume that any of the organizations involved in these proceedings speaks for them. As a developing nation, Myanmar continues to face significant challenges arising from natural disasters such as earthquakes, floods, and storms, as well as financial constraints, emergency situations, and ongoing internal instability. In this context, it has continuously taken steps to address these issues in northern Rakhine states. Details are given in Myanmar's regular reports pursuant to the Provisional Measures Order. Mr. President, members of the court, Gambia says that Myanmar does not recognize the right to exist of the Muslim minority in northern Rakhine State or the right of this population to be in Myanmar. That's untrue. Myanmar considers that Bengalis in northern Rakhine states are culturally, ethnically, and religiously part of the same group as the population living immediately across the border in Bangladesh. However, Myanmar accepts that even if this is so, those living in northern Rakhine State would be a part of that group for purposes of the convention. Conversely, even if the court were to find that those living in northern Rakhine states are a protected group in their own right for purposes of the convention, this would not of itself mean that the ethnicity, culture, or religion is any different from that of those living in the immediately adjacent territory of Bangladesh. There is therefore no need for the court to consider cultural, ethnic, and religious comparisons between those living on the two sides of the border. The Gambia also complains that Myanmar does not use the name Rohingya officially, or instead use the name Bengali. There are, however, justifiable reasons for this. Furthermore, failure to use a particular name in no way implies that the population does not exist or has no right to exist. The Gambia also says that Myanmar does not recognize the member of this population as its citizens. Again, even if this were true, it would not mean that Myanmar has a genocidal intent. But in fact, many Bengalis do indeed have one or another type of the three types of Myanmar citizenships. There are others who will be recognized as having one or another of the three types of citizenship if they were to make an application for such recognition. There are also some who are not entitled to any type of citizenship in Myanmar. Again, there are reasons for this. The first step for a person making an application for citizenship is to apply for what is called a National Verification Card, or NVC. There are around 200,000 Bengalis holding citizenship cards across the country and 50,000 Bengalis holding NVC in Rakhine State alone. Those who apply for an NVC and are found not to be entitled to citizenship can continue to live lawfully in Myanmar as the holders of NVC. Despite this, many Bengalis in northern Rakhine states refuse to engage with the NVC process. Some refuse on political grounds, some refuse because they are pressured by activists not to do so, or have received false information from activists that anyone who applies for an NVC will never be granted citizenship. All this has nothing to do with genocide. Like in other states, the Myanmar Constitution gives equal rights to all Myanmar citizens. No one can be politically discriminated for their origin and belief. Section 391A of the Constitution allows all eligible citizens to vote in the election. As we speak, the multi-party general elections are underway in Myanmar, starting from 28 December 2025. The elections are being held in 3 phases, and all eligible voters, regardless of ethnicities and religion, came out to cast their votes. 57 political parties and almost 5,000 candidates are contesting for various constituencies, including Rakhine states. There are 154,049 Bengalis in Myanmar who are eligible to vote in the current elections. Mr. President, members of the court, let me also clear that Myanmar is committed to achieving the repatriation to Myanmar of persons from Rakhine State currently living in camps in Bangladesh. There were 2 previous instances of mass migration from Myanmar to Bangladesh in 1978 and 1991-1992, respectively. On both of those 2 previous occasions, Myanmar was able to successfully repatriate those concerned in accordance with agreements made through bilateral consultations with Bangladesh. Likewise, following the events of 2016 and 2017, agreements were quickly made between Myanmar and Bangladesh for the return of displaced persons from Rakhine states. Comprehensive measures to resettle and rehabilitate the returnees are also being put in place, such as providing security, education, healthcare, food, and job opportunities with international cooperation, including from the United Nations. Since 2019, we have also had informal tripartite working groups and discussions on the repatriation process involving Myanmar, Bangladesh, and China at the senior official and vice ministerial level. We also invited diplomats, delegates of displaced persons themselves, as well as the media, to witness these comprehensive measures firsthand. In addition, we have a comprehensive plan for resettlement and rehabilitation of the returnees, including one-stop service for the issuance of NVCs and application for citizenship, temporary livelihood supports and shelters in transitions, new settlement arrangement near original places, distribution of land use for farming, income generation programs, health and education facilities, etc. Myanmar's commitment and constant efforts since 2017 contradict the Gambia's narrative that Myanmar's intention is to destroy or forcibly deport this population. However, although Myanmar had tried its utmost, there have unfortunately been setbacks to the repatriation processes. These have included the COVID-19 pandemic from 2020 to 2022, Cyclone Mocha, which hit the northern Rakhine area in 2023, and instability in Rakhine State. Circumstances not Myanmar's making have so far prevented the actual commencement of repatriations. It will be seen on examination that these proceedings are, in fact, being used as a vehicle to advance agendas that have nothing to do with the Genocide Convention, such as demands that the name Rohingya be used officially and that all of those currently living in the camps in Bangladesh automatically be given citizenship of Myanmar upon being repatriated to Myanmar. Mr. President, members of the court, Myanmar does not have trust in the impartiality of the independent international fact-finding mission on Myanmar or of the independent investigative mechanism for Myanmar, and does not accept the claim accuracy or reliability of the information in the documents or in other documents relied on by the Gambia. It is therefore essential to Myanmar that the court evaluate all of the detailed evidence itself and not rely on opinions or the conclusions expressed by any other bodies, especially if these are not based on the first-hand evidence. In these proceedings, Myanmar asks the court to do no more than apply the terms of the Genocide Convention as they were so carefully negotiated in 1948 and to follow its own case law, which is now well established. Myanmar respectfully asks the court to look very carefully at all of the evidence in detail and to reach its own judgment of the facts. Myanmar is confident that the court will act independently and impartially and will consider the evidence fairly and objectively. Mr. President, members of the court, I thank you for your kind attention and I would like to ask you, Mr. President, to now call upon Dr. Staker. Thank you.
I thank the agent of Myanmar. I now give the floor to Mr. Christopher Staker. You have the floor, sir.
Mr. President, Madam Vice President, members of the Court, it's an honour for me to appear before you again. I present arguments for the Republic of the Union of Myanmar, together with my colleagues, Mr. Blom-Cooper, Ms. Laurie, Professor Tauman, Professor Moron, Mr. Hooper, and Ms. Cordoni, each of which will address you as counsel in due course. I also acknowledge the invaluable contribution to the work on Myanmar's case of Ms. Diana Ellis, KC, a distinguished advocate at both domestic and international levels who passed away after the closure of the written pleadings. Her wise counsel is sadly missed. Mr. President, members of the Court, an accusation of a violation of the Genocide Convention is a matter of the utmost gravity. Such a serious claim demands the most careful attention, and Myanmar trusts that this is what the Court will give to this case. Not all accusations are well-founded. Indeed, not all are even made in good faith. A court of law must begin without any preconceptions and must maintain an open mind. Myanmar's written pleadings set out in full its response to the claim of the Gambia. Myanmar appreciates that the written pleadings are lengthy. However, the gravity of the allegations demands that they be given comprehensive examination by the Court in all their meticulous detail. Guided by Article 60 of the Rules of Court, Myanmar will, in these oral proceedings, focus on the main points still dividing the parties. However, in relation both to matters not addressed in oral argument, as well as those that are, Myanmar relies on the Court's most careful attention being given to the written pleadings. I emphasise this because the Gambia seems quite keen that you not look at the case in too much detail. It dismisses discussion of details as micro-nits or even nano-nits, or as something from a novel by Dickens. To lighten the Court's task slightly, I can say immediately that one matter is not in dispute, namely the importance of the Genocide Convention. It is no part of Myanmar's case to seek to downplay its significance. It is precisely because of its importance that Myanmar has taken such care in responding to this case. It is precisely because of that importance that the response of Myanmar deserves such anxious consideration. Counsel for the Gambia have spoken eloquently of the background to the Convention and the values underlying it. Few would disagree with Professor Sands's statement that the Genocide Convention is emblematic of who we are, of who we wish to be, of how truth and law are to address matters of raw power. However, statements such as these do not assist a court in applying the Convention to the circumstances of a particular case. The present proceedings are not criminal proceedings. They are interstate proceedings concerning a claim that Myanmar bears international responsibility for a breach of its obligations under an international convention. Nevertheless, these are not quotidian interstate proceedings. They are extraordinary in at least two significant respects. First, this is a case in which a significantly higher burden of proof applies than in the generality of cases before the court. The Gambia accepts that in principle. Although these are not criminal proceedings per se, the applicant alleges that Myanmar is internationally responsible for the crime of genocide. According to settled case law, the standard of proof is effectively the same as the beyond reasonable doubt standard that applies in criminal proceedings before international criminal courts and domestic criminal courts. No higher standard could apply. Secondly, this is the first case in which a state that has not itself been directly affected by the facts of a case brings proceedings on the basis of the common interest of all states parties in ensuring compliance with the Genocide Convention. An applicant acting in the common interests of all states parties must be expected to exercise due care. The Gambia appears to accept this. Mr. Reichler spoke of a particular obligation on Council to be as careful as possible in dealing with the law and the facts accurately and objectively, and to be as helpful as possible to the court in its effort to provide the right answers on the important issues that have been raised. Mr. Jallow claims that the Gambia did exercise due care before bringing this case. It may well be that any compromissory clause in any treaty brings with it the risk of proceedings being brought overzealously or in bad faith, or to pursue agendas unrelated to the treaty. However, that risk is multiplied many times when any state party can bring proceedings against any other without having to be specially affected by the subject matter of the claim. That is all the more so in the case of a treaty with as many participants as the Genocide Convention. The need for due care is obvious. Myanmar itself is one of the states parties to the Convention in whose shared common interest the Gambia is said to be acting. That common interest is, of course, an interest in ensuring compliance with obligations under the Convention, not an interest in upholding every accusation of genocide. Prior to the institution of proceedings, there is no mechanism for determining whether an applicant state is genuinely acting in the common interest of all states parties, or whether it is acting in compliance with its duty of care. The only control is by the court itself after proceedings have been brought. The court can exercise that control by maintaining the highest rigour in the evaluation of the claim and by expecting rigour on the part of the applicant. Any court must always be dispassionate, rigorous and objective. In proceedings of the present kind, the court should also expect the same of the applicant. Mr. President, members of the court, in a court of law, genocide is a specific legal norm. There are particular elements that need to be proved to establish a breach by a state of its obligations under the Convention. Not every injustice, nor every violation of international law is a violation of the Genocide Convention. And in a case such as the present, where the sole basis of the court's jurisdiction is Article 9 of the Convention, the court has no jurisdiction to determine whether the facts disclose any violation of any other norm of international law. For instance, in the Bosnia case, the court found that certain killings were not genocide, adding that they may amount to war crimes and crimes against humanity, but the court has no jurisdiction to determine whether this is so. One difference between the Genocide Convention and many other human rights and international humanitarian law conventions is that the Genocide Convention contains a compromissory clause allowing direct recourse to the court for claims of alleged breaches. Some might well hope to see judicial interpretations expand the definition of genocide under the Convention, thus bringing a wider range of matters within the scope of the court's jurisdiction under Article 9. Of course, that would not advance the international rule of law. The international rule of law demands that faithful effect be given to what was negotiated and agreed when the Convention was adopted. And the rule of law demands that the court's previous case law applying the Convention be followed absent good reason to the contrary. The Gambia does not advocate for any different approach. It says that it is here to present its case under the law as the court's jurisprudence has established it, and that it does not question or challenge the legal standards that the court has set. Few will have found it easy to listen to the case presented by the Gambia. However, the court has not yet established the facts, nor has it yet determined whether any facts that may be established satisfy the legal elements of genocide. That is the only question that the court is called upon to determine. And it is therefore to the facts that I now turn. Mr. President, members of the court, two things that are not in dispute are the existence of the Arakan Rohingya Salvation Army, ARSA, and its attacks against the Myanmar security forces in 2016 and 2017. Mr. Reichler concedes that we do not suggest that Myanmar should have ignored ARSA. As a sovereign state, it had the right to defend itself against such an outfit. Myanmar, for its part, does not dispute that its security forces conducted operations in northern Rakhine State in response to those ARSA attacks. By security forces, I mean the Myanmar Defence Services, also known as the Tatmadaw, its official name, the Border Guard Police, and the police. The military operations were of a kind known in the Myanmar language as Ne Mie Shin Lin Ye, which means area clearance operation. To anyone unfamiliar with military terminology, the expression area clearance operation or clearance operation, or its French equivalent, opération de nettoyage, the expression may sound shocking. To an uninformed listener, it seems to carry connotations of ridding an area of all of its inhabitants. In fact, it will be seen that the expression is military terminology used in many countries, including the United States and the United Kingdom, to mean a counter-terrorist or counter-insurgency operation. The French equivalent has the same meaning. The Gambia has never disputed this or explained why it consistently puts the expression in quotation marks. To avoid any confusion, Myanmar uses the term counter-terrorism operations in this case. However, despite this, the Gambia's memorial makes almost no reference to ARSA at all. And extracts of documents annexed to its memorial, including significantly the FFM report, on which the Gambia places so very much reliance, omit the pages of those documents dealing with ARSA, thereby giving a distorted picture of events. This is not consistent with its duty to act rigorously and objectively. The duty of objectivity should have required the Gambia, at the very least, to set out all the evidence relating to ARSA's capabilities and activities. It was, at the time, a professional, well-organised and trained group and had come to wield considerable control and influence in northern Rakhine State. It still exists and is still active, and now also wields considerable control and influence in the camps in Bangladesh, as the court will hear from Ms. Laurie this afternoon. Mr. President, members of the court has before it at present at least 3 different accounts of the facts. The first account is that initially set out by the Gambia in its memorial. This account is pure allegation. As will be seen, it is not supported by the evidence. According to this first account, there was a consistent pattern of conduct following a consistent modus operandi involving mass executions and sexual violence and systematic burning of villages that was repeated in hundreds of villages across northern Rakhine State. The second account is the picture of events that one would have if all of the documents relied on by the Gambia were treated as conclusive proof of what is stated in them. The picture is the following. There was significant violence against persons uninvolved in the ARSA attacks in the 3 villages of Minji, Chut Pien and Maung Nu, which Myanmar refers to as the 3 main locations. Events in those 3 villages occurred in August 2017. There are 4 other locations, Gudar Pien, Indin, Khotan Kauk and Chain Ka Ali, in which there is evidence of violence against persons uninvolved in the ARSA attacks, but not on the same scale as in the 3 main locations. There is then evidence of violence against persons uninvolved in the ARSA attacks in a number of other locations. The Gambia claims that the UN fact-finding mission identified 47 other such locations, such that the total is 54. However, in respect of these other locations, the evidence often does not even allege anything more than a single incident involving a single victim, or a very small number of victims, and often not even a single fatality. In August 2017, there were 509 locations in northern Rakhine State that were wholly or partly inhabited by Bengalis. In relation to the remaining several hundreds of villages across northern Rakhine State, the Gambia presents no evidence at all of physical mistreatment of the civilian population by Myanmar security forces. Furthermore, the Gambia's evidence shows that almost all of the operations of the security forces occurred in the 3 days from the 10th to the 12th of October 2016, the 3 days from the 11th to the 13th of November 2016, and the 7 days from the 25th to the 31st of August 2017. That is to say, in the few days immediately following each of the three main ARSA attacks. Those operations took place in locations proximate to where the ARSA attacks had taken place. Additionally, there's no suggestion that the 126,000 Bengalis living in camps for internally displaced persons in Rakhine State came to any harm in 2016 or 2017, or that they've come to any harm since, despite the fact that they would have been an easy target in any genocidal campaign. What is more, hundreds of thousands of Bengalis who live in towns and villages in Rakhine State did not leave to go to Bangladesh and continue to live in towns and villages in northern Rakhine State today. The regular reports that have been filed by Myanmar pursuant to the Provisional Measures Order gives details, amongst other matters, of the medical, educational and food aid being provided to Bengalis in northern Rakhine State by United Nations agencies, international aid agencies and non-governmental organisations, as well as the medical, educational, financial and other assistance being provided to them by the government of Myanmar and the Myanmar Defence Services. As to those who did leave northern Rakhine State for Bangladesh, there is evidence of people repeatedly passing and interacting with the military and police personnel on the way who made no effort to harm them. Moreover, the Gambia does not dispute that as early as November 2017, 2 months after the August 2017 operations, Myanmar entered into agreements with Bangladesh for the repatriation of those who went to Bangladesh, and Myanmar has since been working actively with Bangladesh, UNHCR and others to begin the repatriation process. The third account of events is the one that the court will decide for itself after it has considered the evidence presented by both parties and has made its own assessment of the evidential weight of each item of evidence. The position of Myanmar is that the evidence presented by the Gambia is not of sufficient evidential weight to establish, to the very high standard of proof applicable in this case, that each of the specific alleged atrocities occurred. That is all the more so if the evidence relied on by the Gambia is considered with the evidence presented by Myanmar. There's no reason why the court should, without more, give preference to the evidence presented by the Gambia to the extent of any inconsistency with Myanmar's evidence. Furthermore, even if the court were to find that any of the alleged incidents occurred, the facts that would be found to be proved would fall far short of what is required to establish all the elements of genocide. Again, the Gambia has not observed its duty to act rigorously and objectively. It does not set out fairly and objectively all of the evidence as a whole. Nor does it do so in relation to its allegations of discriminatory laws and policies and hate speech, which will be addressed in due course. Mr. President, members of the court, aside from the disputed facts, there are important differences between the parties concerning the evaluation of evidence. A very large amount of material has been annexed by the parties to their pleadings, and further material was added to the case file after the written proceedings closed. Yet, despite the volume of this material, The Gambia's case is ultimately founded on reports of the Independent International Fact-Finding Mission on Myanmar, the FFM. These reports were issued in 2018 and 2019, some 6 and 7 years ago. Other evidence is referred to by the Gambia in only a subsidiary way. Other evidence is said by the Gambia to be relevant because it is consistent with or corroborates aspects of the FFM reports. However, there's no suggestion that the remaining evidence would on its own be capable of establishing the Gambia's claims of genocide in the absence of the FFM reports. This is clear in the Gambia's written pleadings and has been made clear again by the Gambia in oral argument. When identifying the Gambia's evidence in the case, Mr. Jallow referred to FFM reports multiple times and went on to clarify that the significance of the NGO reports from the Gambia's point of view is that they are said to corroborate the FFM reports. Professor Sands and Mr. Suleiman described the FFM reports as authoritative and confirmed that the Gambia's evidence is underpinned by the FFM reports, and says that the value of other material also lies in its consistency with and confirmation of the findings of the FFM and the IIM, which serves to underscore and enhance the reliability and weight of the FFM's 2 comprehensive reports. Mr. Reichler says we place special emphasis on the reports by the FFM and the IIMM, including all of the underlying material on which the reports are based. Although Mr. Reichler says that the Gambia places special emphasis on reports by both the FFM and the IIMM, there is, however, no suggestion that the IIMM material itself could be sufficient to prove genocide. Mr. Reichler furthermore only speaks of emphasis being placed on IIMM reports rather than IIMM witness statements. The IIMM reports do not deal directly with events on the ground in 2016 and 2017, but rather with ancillary matters such as ARSA weapons possession and hate speech and detentions in prison and efforts to prosecute sexual violence. As to the witness statements produced by the IIMM, it's a striking fact that the IIMM has provided some 42 witness statements to the Gambia, and the Gambia has only put 12 of them into evidence in this case. I ask you to pause and think about this. The very institution set up to gather evidence and to produce evidence specifically for use in judicial proceedings and with access to the accounts and identity of all of the hundreds of FFM interviewees, provides just 42 witness statements relevant to the allegations after over 7 years of work. And then the Gambia only files 12 of them. The fact is that unless the FFM reports are given sufficient evidential weight to enable the Gambia to discharge its burden of proof to the requisite high standard, the Gambia simply has no case. Its entire case rests on reports of a fact-finding mission that is 6 or 7 years old and were drafted during a short period of time without proper investigation backing them. In the intervening years, no further evidence has emerged that would be capable of proving a claim of genocide without central reliance on the FFM reports. However, the FFM reports cannot be given evidential weight in relation to the events on the ground in northern Rakhine State in 2016 and 2017. The reasons will be addressed fully in due course. Apart from anything else, the FFM was not a body that was equipped or qualified or had a mandate to produce evidence suitable for use in judicial proceedings, and certainly not to make ultimate findings of fact in accordance with the standard of proof applicable in this case. And it certainly did not apply the standard of proof that the court is required to apply in this case. However, there are also more fundamental reasons why the FFM reports are not capable of enabling the Gambia to discharge its burden of proof to the requisite high standard. The court is a judicial body. It cannot find a state responsible for so grave a matter as genocide, which requires proof to a high standard without proper judicial process. A state defending itself against such a grave accusation must be capable of contradicting and testing the evidence against it. Given the seriousness of the allegations and the fact that proceedings are brought in the common interest of all states parties to the Convention, proceedings of the present kind must be a genuine search for the truth, which requires a proper adversarial process. The Gambia says that the court can rely on the FFM reports, quote, to assist in its own determination of the facts. Yet how is the court assisted by the FFM reports in making its own determination of the facts? The FFM reports simply state bare findings of fact and then cite to unidentified persons as the source of that information, or state conclusions of the FFM itself based on those findings of fact. How can the court make its own determination of facts based on such material? It either accepts the material and rubber stamps it, or it rejects it. But how can the court rubber stamp it? The court must be satisfied of facts to a standard of proof comparable to the beyond reasonable doubt standard of criminal proceedings. How could the court be so satisfied on the basis of bare statements of fact attributed to anonymous persons? This case is an absolutely extraordinary case, where the evidence relied upon by the applicant consists of findings by a third party based on hundreds of anonymous people. Neither of the parties knows who the overwhelming majority of these people are. Not only is the court incapable of making any genuine determination of its own on the basis of these reports, but the respondent also is incapable in any way of challenging or testing the credibility of the evidence. The fact that the FFM reports are accompanied by a sprinkling of other evidence changes nothing. That other evidence collectively is incapable of proving genocide, so that a finding of genocide would still rest on the untestable FFM reports in any event. Furthermore, while that other evidence may be consistent with aspects of the FFM reports, the body of evidence does not corroborate the FFM reports as a whole. That other evidence also has similar deficiencies to the FFM reports. It includes, for instance, reports of other official bodies or NGOs that contain bare statements of fact attributed to anonymous persons. Effectively, the Gambia seeks to shift the burden of proof. It seeks to put Myanmar in a position where Myanmar has the burden of disproving what is stated in the FFM reports. This is, of course, contrary to the established jurisprudence, according to which it is for the applicant to demonstrate the existence of the facts put forward in support of its claims. The court cannot demand of the respondent that it provide explanations of the facts alleged by the applicant. A further objection to reliance on the FFM reports is that Myanmar was under no obligation to cooperate with the FFM, and it did not do so. This means that the FFM reports, in any event, reflect only one side of the story. The Gambia seeks to ridicule this argument. That may be a sign that it has no answer to it. The effect of the Gambia's argument would be to force states to cooperate with bodies that they are under no obligation to cooperate with and have no desire to cooperate with. The FFM has no power to say to Myanmar, you have no duty to cooperate, but if you do not, you may be prejudiced in any future proceedings before the International Court of Justice. Members of the court, would any municipal court that observes the rule of law convict a person of the gravest crime or find against a defendant in the highest stakes civil case on the basis of a report prepared by a third party that simply states facts attributed to anonymous persons? If any municipal court did that, would that be called a legitimate exercise of its fact-finding responsibility? Or would that be called an abnegation of its judicial function? The Gambia may disagree, but the answer must obviously be the latter. Myanmar does not take the extreme position that reports of United Nations bodies can never have evidential weight. Obviously, such reports have been given evidential weight for certain purposes in certain cases. However, there is no precedent for making findings of the core facts in a case where the heightened standard of proof applies on the basis of a report such as this. Contrary to what the Gambia seems to suggest, this is not the court's long-standing practice. In previous cases, the court has exercised due care when relying on reports of United Nations bodies and has rejected claims evidenced by such reports. It has not treated them all as authoritative. The court has affirmed multiple times that the probative value of reports from official or independent bodies depends, among other things, on 1, the source of the item of evidence, for instance, partisan or neutral, the process by which it has been generated, for instance, an anonymous press report, or the product of a careful court or court-like process, and 3, the quality or character of the item, such as statements against interest and agreed or uncontested facts. The FFM reports were certainly not produced by a court or court-like process, and there would have been no such process even if Myanmar had cooperated with it. The sources of evidence in the reports, that is to say, claimed eyewitnesses to events, cannot be considered neutral. Furthermore, the information in the reports is not agreed or uncontested and does not fall in the category of statements against interest. The Gambia suggests that Myanmar's position would make it all but impossible for a state to be held accountable under the Convention. In fact, in some cases, it may well be impossible to hold a state accountable, for instance, because the state is not a party to the Convention, or because the state has made a reservation to Article 9. However, in the case of a state party that has made no such reservation, the way of holding a state accountable is to bring proceedings before this court. Contrary to what the Gambia appears to assume, Myanmar's position would not create a need for a prior determination by a third body, such as the ICJ, before proceedings are brought before this court. If all of the evidence that was before the FFM was before this court, then the court could have considered that evidence itself and made its own findings based on it. This would not involve importing the rules of the International Criminal Court or other rules of criminal procedure into proceedings before this court, and would not necessarily involve the hearing of oral testimony from every witness. This court is always subject to its own statute and rules of court. There may well be challenges in managing such litigation, but not insurmountable challenges. No other court in the world would shy away from hearing the largest, most complex and most serious cases on the ground that it is hard to do. It's a hypothetical question precisely what evidence would be sufficient to prove genocide in a case before the court. For present purposes, it suffices to confirm that reports of the FFM are insufficient. Mr. President, members of the court, in addition to the disputed issues of fact and disputed issues of evaluation of evidence, there are also certain disputed issues of law in this case. These are most conveniently dealt with as they arise in the course of presentation. I will therefore not identify all of them now, other than to mention three. First, the Gambia appears to suggest that if a genocidal intent is one possible inference to be drawn from the circumstances, it will be proved unless the respondent proffers and presumably proves some other explanation for that conduct. That is incorrect. According to the court's settled jurisprudence, the Gambia bears the burden of proving all legal elements of the claimed breaches of the Convention, in accordance with the high standard of proof that applies in cases of this kind. In the Bosnia and Croatia cases, the court did not require the respondent state to plead, let alone to prove, an alternative explanation of the evidence. As long as there is a reasonable alternative inference, a genocidal intent will not be the only reasonable inference. Second, the Gambia has said that a victim of genocide must be part of a recognizable and definable group, suggesting that a single individual can be a part of a group for purposes of Article 2 of the Convention. That is incorrect. The words "in part" in Article 2 of the Convention mean a distinct and identifiable part of the group. Normally, but not necessarily, a part of a group living in a particular geographic region. Thus, in the Bosnia case, the court found that the Bosnian Muslims of Srebrenica were part of the protected group of Bosnian Muslims. Simply targeting large numbers of members of a group because they belong to that group does not of itself amount to targeting an identifiable part of the group. Furthermore, the Court has held that such an identifiable part must represent a substantial part of the overall protected group, since it could distort the definition of genocide if too small a section of the protected group is considered to be a part of the group for the purposes of Article 2. The Bosnian Muslims of Srebrenica were only a small part of the overall group, but in that case they were held to be a part for purposes of Article 2 because of the immense strategic importance of the area. Such a small portion of a group would normally be insufficiently substantial to constitute a part of the group for purposes of Article 2 of the Convention. In the present case, the Gambia has said that there were numerous Srebrenicas, suggesting that the inhabitants of every location where operations took place in 2016 and 2017 were a part of a protected group for purposes of Article 2. That simply cannot be assumed or asserted. No basis has been established by the Gambia for suggesting that individual small villages satisfy that definition. Thirdly, the remedies that can be requested for violations of the Genocide Convention must be confined by the norm that is said to be breached. Claims cannot be brought under the Convention as a vehicle for advancing demands unrelated to genocide. A breach of this principle can be found in the submissions at the end of the Gambia's written pleadings. The Gambia seeks orders from the court requiring Myanmar to, quote, ensure the protection of the Rohingya against discrimination and persecution. To, quote, ensure the right of the Rohingya to identify as such. To, quote, ensure the liberty and freedom of movement of the Rohingya within Myanmar. To, quote, remove any restriction or discrimination on the employment or access to livelihoods of the Rohingya, and to grant, quote, full and equal citizenship to all members of the Rohingya group. This is a sweeping agenda. If the Gambia says that all of these submissions claim rights under the Genocide Convention, then it seeks to extend radically the concept of genocide to include a right to citizenship, a right to work, and the right to be referred to by a particular name. On the other hand, if the Gambia says that these submissions claim rights under norms of international law other than the Genocide Convention, then it seeks to use the Convention and its Article 9 to enforce claimed rights under international law other than those under the Convention. In fact, the Gambia seems to be going much further than this. It seems to ask the court to order Myanmar to confer these rights on the Bengali population, whether or not these rights even exist under international law, on the basis that these are claimed remedies for claimed violations of the Genocide Convention. If so, the Gambia seeks to use the Genocide Convention to achieve goals that are political rather than legal. None of these three possibilities is consistent with what was intended at the time of adoption of the Genocide Convention. Mr. President, members of the Court, before moving on, I wish to note two matters that should not occupy the Court's time. The first is the question of the existence of a protected group. In light of what the agent for Myanmar has just said, it is accepted that acts aimed at the destruction of the Bengali or Bengali Muslim population in northern Rakhine State as such would fall within the scope of the Convention, irrespective of whether that population is a part of a protected group or a protected group in its own right. The second matter is the question whether genocide can be committed in an armed conflict. Myanmar has never suggested otherwise. The massacre at Srebrenica, which the court in the Bosnia case found to be genocide, was also committed in an armed conflict. Myanmar also accepts that genocide can be committed during a counter-terrorism or counter-insurgency operation. However, that does not mean that the existence of an armed conflict or counter-terrorism operation is irrelevant to the question of what inferences of fact can be drawn from the circumstances as a whole. The existence of an armed conflict or counter-terrorism operation may provide a basis for allowing reasonable inferences that do not involve genocide. Mr. President, members of the Court, that concludes my introduction. To assist the Court, Myanmar's oral arguments will broadly follow the same structure as both of its written pleadings. In each of Myanmar's written pleadings, each chapter has the same title and deals with the same subject matter as the corresponding chapter bearing the same number in the other written pleading. I've just dealt with introductory matters, the subject of Chapter 1 of both written pleadings. If this would be a convenient time for the customary coffee break, I could resume after the break with the subject matter of Chapter 2 regarding certain background facts.
Mr. Speaker, the Court prefers that you continue, and after your presentation, the Court will take a break.
I'm in your hands, Mr. President. Thank you. Mr. President, members of the Court, it will assist you if I address at the outset certain background facts that are necessary to dispel some of the Gambia's mystifications which fog the debate. This background is relevant in particular to issues concerning the names Rohingya and Bengali, the 1982 citizenship law, and hate speech. This is Chapter 2 of the written pleadings of Myanmar. The relevant historical background of the Bengali-speaking population in northern Rakhine State is as follows. There was a population of Bengali speakers in Arakan even before Burma became part of the British Empire. You'll be aware that Arakan is the former name for what is now Rakhine State. The ancestors of those who were there in pre-colonial times came from Bengal. Then, during the British colonial period, there was significant immigration into Arakan from other parts of British India, in particular from the neighbouring Chittagong region of Bengal. The communities originating in these colonial-era immigrations outnumbered the pre-colonial Bengali-speaking communities by about 4 to 1 by 1931, and there is no evidence that they all considered themselves a single community. After Burma's independence, illegal immigration into northern Arakan from neighbouring Pakistan and then Bangladesh was an ongoing problem. During the formation of Bangladesh in 1971, some 100,000 Bengali Muslims moved illegally to Myanmar. During the Second World War, many Bengalis in Arakan fought for the British, while the Burma Independence Army fought for the Japanese. This led to the Alathankyur crisis. Then, following Burma's independence in 1948, a Mujahideen rebellion broke out in northern Arakan with the aim of seceding from Burma. The final Mujahids surrendered in 1961. The background to the name Rohingya is as follows. There is no known reference to the name Rohingya or any variation thereof throughout the entire 124 years of British colonial rule from 1824 to 1948. The name began to be used from the late 1940s by some Bengali Muslims. It has been described as, quote, more of a political label seeking to associate a number of Muslim communities and as being seen, quote, as an activist political identity. It has only been in the last decades that use of the name Rohingya internationally has been more widespread, and even then it did not completely replace the term Bengali. The International Encyclopedia of Linguistics, published by Oxford University Press in 2003, defines a Rohingya as, quote, an ethnic Bengali Muslim who speaks the Muslim variety of Chittagonian Bengali and was born in Arakan State. A United Nations document from 2004 refers to, quote, the Bengali people residing in northern Rakhine State, also known as the Rohingyas. The Gambia identifies no instance of the use of the name Bengali being contested by the international community prior to the 2010s. The word colour is not officially used in Myanmar. It is used in everyday language in Myanmar. It was a term originally used by pre-colonial era Bengali communities to describe themselves. Views differ on the extent to which the word is considered offensive today. Myanmar accepts that many now consider it offensive. The Gambia has not expressly disputed these facts, which should thus be regarded as proved, indeed undisputed. Mr. Suleiman has referred to 3 publications from the 18th and 19th century that make reference to the Rohingya. In fact, the second and third publications merely cite the first, and the first does not in fact establish that Bengali speakers in Arakan self-identified by that name in the 18th century. Furthermore, a study by the United States Institute of Peace, based on research in 2018, shows that 7 out of 10 Bengali Muslims in Rakhine State prefer not to self-identify as Rohingya, even to researchers who themselves identify as Rohingya. The final report of the Inquiry Commission on Sectarian Violence in Rakhine State also suggests that in 2012, a majority did not self-identify by that name, except when pressured to do so by leaders. In the circumstances, the court cannot simply proceed on the basis that a majority of Bengalis in northern Rakhine State do self-identify as Rohingya. In any event, given the uncontested facts I've set out, it's difficult to understand how it could be argued that the official use of the term Bengali rather than Rohingya is somehow evidence of a genocidal intent. Mr. President, members of the court, as to language, the evidence presented by Myanmar indicates that the Chittagonian dialect of Bengali is a continuum of dialects that extends from the north of Chittagong division in Bangladesh to the south of Rakhine State in Myanmar. There are geographic variations in the way it's spoken within northern Rakhine State itself, as well as variations within Chittagong Division. Along this continuum, the way that it is spoken immediately either side of the border between Bangladesh and Myanmar is virtually the same. The evidence presented by Myanmar further indicates that in addition to linguistic commonality, culturally, Bengalis in northern Rakhine State are not materially distinguishable from those in Chittagong Division in Bangladesh. The British Embassy in Dhaka reported in 1992 that Bengali Muslims from northern Rakhine State, quote, speak the same language dialect as in the Cox's Bazar district in Bangladesh and look exactly like the Bangladeshis they are joining. The Gambia does not demonstrate or even assert that the religions of Bengalis in northern Rakhine State are different to those practiced in the Chittagong Division in Bangladesh. Mr. President, members of the Court, I turn finally to the subject of repatriations from Bangladesh. The Gambia's reply makes a generic claim, unsupported by particulars or evidence, that Myanmar is making inadequate efforts for the repatriation and resettlement in Myanmar of those living in the camps in Bangladesh. This would be irrelevant even if it were true. Failure to make adequate efforts for repatriation would not be the physical or biological destruction of individuals in those camps, let alone of all Bengalis in northern Rakhine State as such. Nor would it be evidence of an intent to bring about such physical or biological destruction. Nonetheless, details of the efforts made by Myanmar in respect of repatriations are set out in the written pleadings of Myanmar, as well as in the provisional measures reports. The Gambia does not take issue with the detailed facts advanced by Myanmar, but just relies on general statements. The evidence presented by Myanmar is not seriously contested by the Gambia. As recently as July 2025, a resolution of the Human Rights Council urged Myanmar to commence the voluntary, safe, dignified and sustainable repatriation and subsequent reintegration of all forcibly displaced Rohingya Muslims. And the ASEAN Summit has expressed its, quote, support for Myanmar's commitment to the safety and security of all communities in Rakhine State and the safe, dignified, voluntary return of displaced persons. Bangladesh itself expresses eagerness for repatriations to commence. Such calls by the international community are hardly consistent with any genuine belief that Myanmar has committed genocide against this population or continues to do so, as alleged by the Gambia. There are various reasons why no repatriations have taken place so far, including the security situation in Rakhine State. The evidence also includes statements made in a media interview by the then chairman of a standing committee of the Bangladesh National Parliament and former Foreign Minister of Bangladesh, who gives additional reasons. He states that international organizations and some countries block repatriation through various reasons, including by raising the question whether those to be repatriated will be granted citizenship if they return, and that those to be repatriated raise too many demands. He had previously made similar statements when Foreign Minister. Another of the reasons is that ARSA has a pervasive presence in the camps in Bangladesh, where it intimidates and even kills Muslim community leaders who disagree with its aims and views. There is ample evidence of this, as well as of the fact that ARSA opposes the repatriation process and has threatened and killed community leaders that have supported repatriation. The Gambia gives no clear explanation of how it can even be argued that the lack of any repatriation so far evidences a genocidal intent on the part of Myanmar. Mr. President, members of the Court, that concludes my presentation of Chapter 2 of Myanmar's written pleadings. I thank you for your careful attention. If now would be a convenient moment for the coffee break, I would invite you thereafter to please call on Professor Miron.
I thank Mr. Staker. Before I give the floor to the next speaker, the Court will observe a break of 15 minutes. The sitting is suspended.